All right, well, welcome. Today, my name is John Mazzara with Remax Results, and I have Mike Kallas. Mike Kallas has a law firm here in the Twin Cities, and we're going to talk about real estate and the law and some of the different things that an attorney can do for you with regards to identifying the right structure to own your real estate and evictions and titling and all sorts of things. So we're going to have a conversation about that. And before I do, I'd just like to go ahead and have Mike introduce himself briefly and tell us who he is and what his law firm does.
Thank you, John. Thank you very much for inviting me to be involved in your presentation today. I really appreciate the opportunity. I practice law in three main areas: real estate, business, and estate planning. And I think as we're going to talk about today, those areas often overlap. So, for example, my real estate might involve setting up a business entity as part of that real estate transaction. It might also involve some estate planning, perhaps involving a living trust or involving some other aspect of estate planning. So those are sort of the three areas that revolve around each other and that I practice in. I've been practicing for 37 years and enjoying every minute of it.
Awesome, awesome. Well, that's great. Mike, now sometimes when people want to buy real estate, they don't know how exactly they should own it. Should they own it themselves? Should they own it in some form of an entity, whether that be an LLC or a corporation, or take the LLC and take a certain tax status, an S corp or whatever, and let it flow through. And if they don't know what to do, I'm not an attorney and I'm not an accountant, so I don't want to give them that advice. Those are the type of entities they need to tell me that they want on the purchase agreement. So assuming they want to go ahead and get some advice, how would they start with you? And can you describe a little bit about maybe just on an overview basis of those entities and maybe some advantages, disadvantages?
Sure. In terms of retaining my services, I often represent clients on just a consulting basis where they might hire me for a limited period of time just to give them advice on how they should proceed. I think it will depend on the nature of what they intend to do. If they are going to be residing in the property, it's almost universally the best option for them to own that as an individual. Minnesota law allows for a substantial exemption from creditors if you live in the property and own the property you live in, a homestead exemption. It protects equity in that property for up to $350,000. Also, if you're going to live in that property and you're married, you might consider owning that property as a joint tenant with a right of survivorship. That's a very common mode of ownership. However, there might be reasons why, for estate tax reasons or other tax reasons, why you would consider owning it in a living trust rather than owning it as an individual. One of the important things to recognize is that if you did decide for tax reasons or other reasons to hold that property in a living trust, you need to make sure that you contact your insurance agent and make sure that insurance coverage is changed to coincide with the ownership. So sometimes I represent clients who have already owned their home, maybe have owned their own home for years, and they've owned it as joint tenants with their spouse. And we decide for various reasons to transfer that property into a trust that I create. And my advice to them will be to send a letter or an email that you keep a copy of to your insurance agent. Advise that agent, I've moved my property into this trust and I want to make sure that the coverage is available. And very commonly what needs to happen is there's a rider that would be issued by your insurance company that would show that you're not only covered as an individual, but covered as trustee of your living trust. So that's kind of the idea of owning it as an individual. I often have clients coming to me and saying, you know what, particularly, by the way, in this environment, clients want to be investors and they want to come in and buy a property and maybe have an eye toward buying multiple properties. Maybe they expect they're going to own a dozen properties before it's done. I always like to suggest that they ought to take one step at a time and not get ahead of themselves in terms of preparing for 20. Let's prepare for one or two. And more commonly, the issues that relate to a property that you're not owning relate to the liability concerns. We obviously want to have insurance that covers that owner from liability. But as you might know, there are myriads of ways the insurance companies will decide that their coverage doesn't apply. You know, that this was an intentional act, or that it was for some other reason your coverage isn't available to you. And in that case, it's nice to not have that ownership in your own individual name, because if it is, and you are sued for some liability, and the insurance isn't covering, or the insurance is insufficient to cover the entirety of the loss, you're going to have personal exposure, and it's going to not only expose the equity you have in that real estate, but it's going to expose the equity you have in other assets that you own. And so the way to restrict that is to own that property in a separate entity and limit the liability to only the assets owned by that entity. Which brings up a point, is if that entity owns 7 properties, now it's the equity in all 7 of those properties rather than the equity in just the one property where the liability arose. And so if you did become a land baron and owned 20 parcels, you might consider owning 2 or 3 in each in a separate entity. So you have a separate silos of wealth, and you say, okay, well, this silo is limited to 2 properties. And if there's either of those properties has a problem, the exposure is limited to that silo, and it's not going to bleed over to my other silos that are separate and independent. Doesn't happen often that I have clients with those separate silos. There's an advantage that I just described, that you can isolate the liability to the one enterprise. The disadvantage is that you may be creating additional administrative overhead. Now you've got separate tax returns, perhaps, or separate accounting issues, and separate insurance policies, separate things that you need to worry about for each of those enterprises that you would have been able to consolidate and maybe save some overhead by having had all of them in one enterprise. I don't know if I've kind of rambled a little bit there, but
no, that was great. That brought actually a couple ideas that I wanted to mention or ask you is, sometimes what I've seen with people is when they set up things, let's say on their own, but then they commingle things, they write checks out of their own personal account, or money comes back and forth, and they don't have an annual meeting. I mean, so they're not an entity, even though they think they're an entity. And then, so I guess the question that I had is if and when they maintain these entities, documentation of things like the annual meetings and not commingling, how important is that? And as an attorney, let's say you were representing somebody that set this up, would you tell them that if they don't do that, they're going to pierce the veil and come at them, and they're not going to have the protection? So could you explain maybe a little bit about that? And then a follow on to that is, let's say they say, oh, I like the idea, let's set up these silos, but everything right now is in my name. Is there any type of a look back period where, let's say I deed from me to my corporation or my entity? Is there, I'm assuming I'm not being sued yet. Is there any type of a look back where it couldn't be, I'm going to say, looked at as a fraudulent transfer, or a creditor couldn't say, well, you just did that because you knew, or that type of thing?
yeah, I'll answer that second question first, that there is not a look back period unless you are being sued or you have knowledge of the threat of a suit. And so just incorporating an asset that you have is a very traditional, typical thing to do. And if you did it, you know, in the normal course of things without a liability looming, there isn't a look back period to address. The issue you raised, it sounds as though you have some knowledge in the area, because the phrases you've used have been appropriate, and one of them being the piercing of the veil. There is this figurative shield that exists between the owner of the entity and the entity itself. And the idea is that I'd use the term silo. You have the asset in this silo, and the liability would stay within the silo. However, if it's not well built, that silo would be penetrable by the creditor, and they could not only get what the assets are that are in the silo, but pierce through that and get the other assets of the owner. In corporate parlance, we call it piercing the corporate veil, but it applies equally to LLCs and other enterprises. And so you're right, the idea of maintaining proper documentation and formalities is one of the main issues there, and commingling is another main issue there. It's very common in my experience that clients create an LLC or they create a corporation and they did it on their own, and all they've done is filed articles with the Secretary of State. And they have not, in my view, that's about maybe 20% of what they should have done in terms of electing officers, electing a board of governors or a board of directors, having an annual meeting and having an initial meeting to, show that they have the requisite formalities. And so it's not an unheard of thing in my practice for me to assist a client in creating the records that would have been created back when the entity was created, and to what I like to consider it as memorializing what was already done and just was not memorialized at the time. And so we might have an enterprise where it's a husband and wife are the owners, and maybe they don't have share certificates or they don't have member unit certificates. Okay, well, we're going to put those back in 2007 when this enterprise was created. We're going to create some member unit certificates, and we're going to do the other things that were needed and proper for the enterprise to actually have a proper existence. We haven't talked much about the options and benefits, but in my practice, I recommend that a corporation have an annual meeting, and it's a pretty mundane, typically, meeting. We elect the directors, we elect the officers. I like to have something customized each year where we talk about, okay, well, we're going to increase the rent, or our new tenants are this, and it doesn't look exactly cookie cutter from year to year. And I actually do those every 12 to 18 months, or recommend that. I don't have that same recommendation for an LLC. I only do LLC minutes when the need arises. And so in my opinion, there's some law out there that says LLCs don't have that same requirement. And it's another reason that I favor LLCs over corporations, because the annual maintenance or the cost of maintenance is reduced by an LLC. I'll just talk with you about the two main options in my practice. One would be a corporation, and the other would be an LLC, limited liability company. Maybe briefly explain why some of them aren't good options. One of them would be a partnership, where you have more than one entity or owner. And if they own it as a partnership, liability is not limited. It actually is expanded, so that if you and I were to own a parcel of real estate together and I screwed up, you would be equally liable with me, and your assets, all of them, not just the partnership assets, would be fully exposed, as would mine. And so you've kind of, adopted all of my screw ups, and I've adopted all your screw ups relative to this ownership that we have. And it's just a terrible way to consider entering into a business. And unfortunately, that's the way it will be by default if we haven't specified anything else. And so if John and I decided to go and buy an apartment building or a duplex together, and we owned it together, we are a de facto partnership. And the screw ups that John had or Mike had on that, in that ownership, would flow to both of us on an individual level. Better would be for me and John to create an LLC or to create a corporation and each own a fractional interest of that entity. And then the liability would be isolated to the assets of that entity, which in this example is just that piece of real estate that we bought together. So in terms of the two main ones, I mentioned partnerships are kind of should be off the table. LLCs have the maintenance costs are lessened by them, in my recommendation. And also there is a feature there. There's a couple of features that put it ahead of a corporation. In a corporation, we have three levels of organization. We have the owners, which we call shareholders. the shareholders, they don't get involved in day-to-day management. They might be the same person as the other levels, but as a shareholder, they don't get involved in the management of the company. The only control they have over management is to elect the next layer, which is the board of directors. And again, that could be themselves. It doesn't have to be. And the board of directors, they're involved in the macro management of the company. And so they decide kind of a macro level whether the company should buy or sell, or should get into a new business or whatever. And they also, as a macro manager, decide the final level of management, which is the officers. So it would be president, chief executive officer, chief financial officer, vice president, whoever those roles would be. The board of directors on a vote basis would elect them. And typically it's done annually or every 12 to 18 months. In the LLC world, it used to be exactly the same in Minnesota, that the LLCs, although the names were different, the process was the same, that the members, instead of a shareholder, we call them members. Instead of a board of directors, we call them a board of governors. And instead of officers, we call them managers. Time flies faster as we get older. And I was going to say a few years ago, it's probably 5 years ago, Minnesota adopted some additional flexibility in their LLC laws. And it allows now for 3 different styles of LLCs. There is a member managed LLC, a manager managed LLC, and a board managed LLC. And so if you chose, that's optional by the creator, you could choose to have a board managed LLC, which makes it very similar to a corporation. You have a board, you have managers and members. You could have, on the other end of the spectrum, a member managed LLC. In that case, you don't have a board, you don't have managers, all you have is a member. And it might be you only have one member. So it creates an opportunity to have a very streamlined sort of operation. You have one member, and that level of flexibility in an LLC is very attractive to me. Another attraction in the LLC is, under the tax laws, we can create something called a single member LLC. And a single member has to have only one member, synonymous with owner, only one owner. But if we have only one owner, there is no need for a separate income tax return for that enterprise. That tax information can be included on the owner's individual personal return as a Schedule C. And so the owner could say, I own 4 different buildings and they're each in a separate single member LLC, or maybe 2 of them are in one LLC and 2 of them are in another LLC. And I don't need 3 tax returns. I can just use my own personal tax return, and I'll have separate Schedule Cs for each of them. And that saves accounting expense and saves the hassle that goes along with all of that. So I think in my practice, probably more and more, I am creating LLCs as the mode of setting up developers or investors to own real estate, for those few reasons that I just described.
Mm-hmm. Now, with regards to the LLC and the single member, what about if could there be 2 LLCs that own one apartment building? So let's say you created the Mike one, I created the John one, and together we created a partnership. Would that be advisable? That way you could do what you wanted with yours and I do what I want with mine?
You certainly could. My own, it adds a level of complexity to it. I try to follow the KISS principle of keep it simple, stupid, and so I like to resist adding layers of complexity to it. The disadvantage of making it simple. The simple, in my view, would be we own one LLC and John owns half of it and I own half of it. The disadvantage to that, and I think what you were driving at, is, well, then it's not a single member LLC, and now we're going to have a separate income tax return. you're right, we are going to have a separate tax return. And the advantage is it's one LLC, and then now I don't have to have two LLCs and a third LLC, and we're having these separate elections and so forth. So it just you'd have to decide, how important to avoid that tax return in comparison to having three LLCs versus one.
Okay, cool. And what about now in a single member, I'm married, so let's say I had a single member LLC that owned let's say a triplex that I was building, let's say. But it's just, I'm the only person. Would that shield any liability or assets? Let's say something goes upside down on that property and they decide to go after the LLC and somehow they're able to pierce it and they're able to get me. Let's say, is my wife protected, or is there some liability if you're a single member LLC owner? Is there some liability shielding from the spouse?
Yeah. If your wife was not an owner, she wouldn't have any liability for any debts just by virtue of being married to you, unless the debt was concerning necessities of life. So food, medical care, those sorts of expenses, a spouse has liability for the debts of their spouse, but investing in real estate would not be in that category of necessity of life. And therefore, if she weren't an owner, she wouldn't have any liability. By the way, there is a feature in an LLC or a corporation to set up something called a transfer on death arrangement in the ownership of the share. And so in my practice, we create member units or share certificates, and they're green or red, and they've got an eagle on them, and they have the name of the company, and then they have the owner's name on there, and it might be for 10,000 member units, and maybe it's certificate number one, it's the only certificate that this person has, and it's signed by the owner. Wouldn't be uncommon in your situation that you would own, it would say 2312 DuPont. I oftentimes, by the way, use the address as the name of the entity. So it's maybe 2312 DuPont LLC. Okay, you know what that one is in case you have another one with a different address, or it's Zimmerman Property LLC. Okay, you've got this LLC called Zimmerman Property. It happens now that it owns a property in Zimmerman and a property in Delano, but you know what it is. And it's Zimmerman LLC, and on the member unit certificate, it says John Mazzara, owner. You might, on my advice, change that to say John Mazzara, comma, transfer on death to wife Mazzara. And then what happens is, if John still owns that LLC when he passes away, without the need for a probate, his wife will become the owner of those member units and will be able to transact and sell the real estate or whatever it's determined necessary for her to do. And part of the reason we'd set up that living trust would be to avoid the need for that probate and the expenses and delays of the probate. That's not the Cadillac arrangement. And Cadillac is maybe not, I should be saying the Tesla arrangement or something a little more modern. Cadillacs, I don't know. Anyway, I'll throw out a scenario. John, what is your wife's name?
Patty.
Patty?
Patty. Mm-hmm.
So let's say you and Patty passed away together. It didn't really work the way you planned to name Patty as a transfer on death beneficiary of that LLC, because you and she are gone together, and now there's probably going to need to be a probate in order to get that LLC transferred to your children or wherever it should go. If instead you owned that as trustee of the John Mazzara Trust, that has all kinds of contingencies built into it. And it says, okay, if my spouse survives, and it's going to go to her, and then it would go on, probably say, if my spouse didn't survive, it's going to go to my kids. And if they're not old enough, it's going to be held until they're managed for them until they're old enough. And in the really unlikely scenario that one of my kids didn't survive, maybe passed away in a common accident with me and my wife, then that share that would have gone to that child is going to go to those grandchildren of that child. And if they're not old enough, that's going to get managed for them. And maybe the real estate will be sold by my trustee, who might be my brother or somebody I designated. And so we've covered things that in all likelihood are not going to happen. Your children are probably going to survive you, but it's possible. And to avoid the expenses and the delays of setting up a guardianship for the kids or whatever might be needed, having that living trust would help to avoid those unfortunate outcomes.
Wonderful. So the trust could control property, and I just thought of something. I have a client that lives out of state. They own property. They live in another state. They own property here in Minnesota. We just actually purchased one this weekend, and they also own down in Arizona. And so I don't believe he's done a whole lot of planning with regards to this, and I'm going to share this video with him afterwards because I think he should reach out to you. But with regards to owning in multiple states and coordination of those properties, they're both, you know, healthy and everything's great, but they now have these 3 different states, you know, Arizona, Montana, and Minnesota. And how would you maybe recommend that somebody like that take a look and coordinate? And I guess it could be somebody else in Minnesota owning in, you know, Texas or another state too. But how would you recommend somebody take all of that, bring it into something that's easily managed so that they could plan for the inevitable of someday?
Sure. Let's describe a little bit about what the alternative would be first of what we're trying to avoid. If did you say this person resides in Minnesota?
No, they reside in Montana.
Okay, let's pretend they reside in Minnesota.
Okay.
Just because it works better for my practice. If they resided in Minnesota and they owned a property in Montana and they owned a property in where else?
Arizona and Minnesota. Yep.
If they didn't do anything and they passed away, there would need to be a probate in Minnesota, or in the reality, there'll need to be a probate in Montana. And then there'll need to be an ancillary probate in Minnesota, and there'll also need to be an ancillary probate in Arizona. So there really will be 3 probates. I happen to be involved right now with that exact situation where I'm undertaking an ancillary probate in Minnesota for somebody who resided in Arizona, had Arizona property, and had Minnesota property. And they can't transact with that Minnesota property without this ancillary probate. And so that's an expense that you just want to avoid if you can, and triply expensive if you have 3 different states to deal with. So what you typically want to do in a scenario like that, it cries out for this living trust, or sometimes referred to as a revocable living trust situation. And there's a variety of different setups. One of them could be a joint living trust with a husband and wife having a single trust. Another could be separate trust where husband has their trust and wife has their trust. And the reasons for the 2 separate trusts would be estate tax driven. If your wealth is so large, you might want to have separate trusts, although there's still opportunities to save estate tax with the single joint trust. But the general essence of it is you'd create the trust. It probably would be a trust in Montana. He ought to go to a Montana lawyer to create that trust. When I create those trusts for people that reside in Minnesota, if they have real estate outside of Minnesota, Hawaii, Arizona, Florida, wherever it might be, I have relationships with lawyers in all those locations, and they prepare the necessary documents to transfer that real estate to the trust. And so that's what would need to happen is first you'd create the trust, and then you'd, to the extent that it's Minnesota, I can do it, and I do it. I transfer that property into the trust. But to the extent that it's in another jurisdiction, I have no license in any state other than Minnesota. And so we need to hire a Wisconsin lawyer or wherever the property is located. And the client pays that lawyer to prepare the necessary documents to transfer ownership of that real estate in that location over to the trust. And very commonly that lawyer will want something in writing from me, verbatim, saying, how do I want the title of that property to be transferred so that it's done done well.
So you can act as a quarterback and help coordinate different strategies, and you have resources to help that happen if it's in different areas.
Correct. Correct.
Okay,
Very common is Florida and Arizona. Those are
sure.
Minnesota hotbeds, but it's Missouri, Wisconsin, Hawaii. They're all possibilities.
Yeah, like if somebody owned a cabin in Wisconsin, now they've got a problem, I assume.
Right.
If
Right.
they die.
If they die without any planning, they'll have two probates, one in Minnesota and then one in Wisconsin. And so you might spend $5,000 to $10,000 on that probate process. And
Per state, or would that be
state.
per state? Okay,
State. Yeah. So say, well, I think I ought to avoid that if I can. And two other reasons to consider avoiding that probate are, number one, it's a public process. And so particularly relatives, maybe most people wouldn't care what John Mazzara had, but some might, and his information would be in the record permanently.
Mhm.
Go down to the government center in Hennepin County and say, oh, look what John owned, even what he owned that wasn't probate property. It all has to be disclosed on the application form. Oh, look at how much wealth John owned, and look how many debts John had. And look where it went. Oh, he disinherited one of his kids, or whatever. And, like as I say, sometimes relatives might be even more interested to know,
Sure.
how did John treat that one kid? And so a trust is the opposite. It is ultra private, and no one has access to that information about how much you had and where it went. And so if you can avoid a probate, it's ideal in terms of privacy, but more importantly, in terms of the cost that and the time you're going to save. Another, maybe, I guess that's that. I guess I forgot my train there, what I was going to talk about.
Oh, well, with regards to setting up things in probate and transferring the real estate in and titling it correctly, I know that I've seen that where people said, yeah, I have a revocable trust or whatever, and then they never transferred their title in. So it never really went in, and then they had to go through probate. And then the coordination of other assets. So when you do that, do you also look at, let's say, beneficiary designations on, IRAs or life insurance or other assets they may own, and actually make sure that they complete the actual transfer? I mean, rather than just paying and getting the book or the documents, but actually make sure they follow through on those transfers.
That's a huge problem and a great question. I call that phase two. When I do my estate planning, I tell clients, when you come to me and we prepare these documents and we sign them up in front of witnesses and so forth, you're going to want to figuratively wipe your brow and say, I'm glad that's finished. And the answer is, it's not finished. You finished phase one. And I tell them, I call it phase two because it's equally important to do that second part of the process, which is to designate proper beneficiaries, to transfer any LLCs or other companies that you might own, to transfer the real estate if that's the appropriate thing to do. All those things are phase two. And I also recommend generally that if the client is younger, in their 30s and 40s, even 50s, probably a living trust is not yet right for you, because you're going to need to do phase two, not just immediately following phase one, but as you transfer your wealth and you decided, you know what, we're going to sell that property, that cabin in Wisconsin, and now we're going to buy a different property in Iowa. Okay, well, you're going to have to deal with phase two for all those transactions that you deal with. And so maybe later in life, if you wait until you're in your 60s or later, you're going to have fewer of those transactions to deal with. And so it's kind of a later in life stage process that you'd get into the living trust scenario, because there's less of what I call hassle factor that goes into maintaining phase two. But it is a very important thing. And I do try to make sure that clients have all their ducks in a row and they've established phase two properly, because you're right. You can create all those documents, but if you don't undertake phase two and keep it up to date, you might still have a probate, which was one of the main things that you were trying to achieve when you set up that plan.
So if they hired you to do this, then they should really be prepared then to, as things change in their life and they acquire or dispose of assets, to make sure that they make a phone call, come and have a meeting and revisit and make sure it's up to date. Or if
Yes,
relationships change and they do want to, give more to one kid or less to another or a different person altogether.
sure. Absolutely. So unfortunately, I can be kind of overseeing the initial phase two part of the process, but it's incumbent on them to remember, yeah, you know what, we do need to do that update. And so clients come back to me periodically and say, we want to make sure things are still as they should be. And so we'll do a survey and audit what they have and how it's titled, how the beneficiaries are designated, and make sure that they are going to avoid the probate that they wanted to avoid, and that they're going to minimize their estate taxes that they're trying to minimize.
Perfect, perfect. Okay, and then just to shift gears just a little bit, so if somebody does acquire rental real estate and they run into problems with the tenant, and I know there's all sorts of landmines out there with regards to different city overlays, and Minneapolis and St. Paul proper being two that I'm aware of that have more onerous overlays of what a landlord can and can't do and needs to disclose. And they may get in a situation where somebody doesn't pay, they don't get to stay, they now have to do an eviction. They can't work it out. Um, at that point, well, they could file, I suppose, in family court and go down and do it themselves, or they may want to involve somebody so that they're not breaking the laws and doing their eviction properly. Can you give the viewers any advice on maintaining, being a landlord properly with maybe their rental requirements, the city's requirements, and then planning for the worst case of maybe an eviction that could occur, and how they should protect themselves from maybe allegations at that point of things that they didn't do, like discrimination, for example, but that a tenant would throw out there just because they want to put up a roadblock.
Mhm. Yeah, so I do get involved with evictions, and I get involved with commercial and residential lease transactions, representing the landlords often and representing tenants as well. And probably the biggest foundational issue is the formation of a proper lease itself. And so if you are going to be an investor investing in residential or commercial real estate, you ought to have a template lease, probably in a Word format or some format that you could edit. And it ought to protect you as well as it can. Those laws change regularly. And so maybe there's disclosures that need to be made about meth, that the property hasn't had meth involved in it. And for example, it used to be that a landlord could put in a phrase that said, if we go to court, you tenant are gonna pay my lawyer fees. That's still available in a commercial setting, and probably would be a proper thing to consider. It's a function of negotiation. The tenant may be less inclined to sign your lease if they have to pay your lawyer fees, but it's not available in that format in a residential lease in Minnesota any longer. Even if it doesn't say it, those lawyer fees will be reciprocal. Whoever loses, and if you provide for lawyer fees, is going to have to pay. And so it could be the landlord is going to pay the tenant's lawyer fees in a residential transaction. And so you need to have a good, strong foundation of a lease. And sometimes, in my experience, having a good, strong lease will avoid some of the games and other issues that the tenant might decide to throw at you, because they see, hey, this isn't going to go as smoothly as I thought. One of the other things that will help to minimize that sort of difficulty is process. I'm a big fan of having checklists and process. And so, for example, part of that process probably should be a inspection checklist. And probably you should have the landlord and tenant review the property in advance and go through and check all the damages and defects that might have been in each of those rooms, and have that tenant sign off at the beginning of the lease. And now when there's damages at the end of the lease, you've got a record of the fact that wasn't there, because whenever I rent my space, I go through my checklist, and one of the checklists is is an inspection sheet with a signature sign off by the tenant. So I think process, will help send a message to your tenant that this is an organized landlord. They know what they're doing, and I'm not going to be able to throw roadblocks as easily as the landlords that don't know what they're doing and don't make a business of doing this well. And if you go to a lawyer, they likely, if they know the area of law, will be able to provide you with that sort of system that you could utilize to, make your operation a business that's less likely to be taken advantage of. Nonetheless, there's no guarantee that you're going to avoid having a tenant refuse to vacate, and maybe you have to evict them as a result. Also, separate process would be you might have to sue for back rent if a tenant does vacate and refuses to pay you for whatever rent is in arrears. Both of those things are parts of my practice. Under the COVID-19 environment that we're in right now, the governor of Minnesota has put a moratorium on evictions. And so at least for the time being, evictions aren't available. And I don't know, I personally think that there's going to come a time where those eviction processes are going to be crazy. There's tenants that aren't paying their rent and landlords that are queuing up or going to be queuing up to start their eviction processes. And there probably will be a great backlog of landlords seeking to evict tenants once the floodgates are opened. We'll see what happens.
With regards to that, and like if somebody goes underground, let's say the tenant didn't pay, then they're going to go live on somebody's couch for a while or in their basement, and they kind of disappear. But you're like, that person owed me X amount of rent. I won, in court. I won, and now how can I get a judgment established so that it stays and follows them? And is that renewable, every 10 years, or can you go into, I've been wronged. I know I can't get the money today, but I'm not going to let that person get away with it. How would you pursue something like that?
Most often I recommend to clients that they proceed in conciliation court, small claims court. There's a jurisdictional limit of $15,000 to that court. And even I've recommended to clients they consider reducing their claim to that amount. I had a recent scenario with a client who's a commercial landlord, and they had a tenant who had some reversals, perhaps from COVID. It was a contractor, which frankly, I think contractors are doing very well these days. They were a contractor, and they stopped paying their rent, and the amount owed was maybe $21,000. And I recommended to the client, because this tenant may be an empty pocket, rather than going to district court and paying me a lot of money, and all they had to do is submit a simple answer and they could have drawn it out for a year or more. Go to small claims court, discount your claim to $15,000, and my crystal ball, which isn't always accurate, was they may well not recover that $15,000. If they had no personal guarantee, which by the way is another thing to consider when you're a landlord, is get a personal guarantee from the tenant. Without it, if that tenant who was a drywall contractor decided to close up their shop and form in a new business under a new name, a new LLC, it would be a very expensive proposition to decide to chase that $20,000 from old enterprise to new enterprise. Very, very likely to spend more than $20,000 pursuing that. And even then, the question whether you recover is in doubt. So that would be generally my advice, would be to try to minimize the expense and strike quick and inexpensively. If instead you've got a claim that's a large claim and the debtor, the tenant is flush with wealth, it's some well-known established company, then perhaps district court is the way to proceed. But that's not a knee-jerk reaction that you would automatically go there. You would only do that thoughtfully and with great consideration.
Perfect. And then if you did win, and if they signed a personal guarantee, then that would follow them. They would, unless they declare bankruptcy, correct? Where they
That's
would,
correct.
they'd be on the hook.
Yeah, I used to, actually, I started my law career working in a bankruptcy trustee's office
Oh,
from 1980 to 1983. I worked in bankruptcy, and even in my younger years, I practiced in the area of bankruptcy law in addition to the things that I'm doing now.
oh,
So I have a fair amount of experience with collection and with avoiding collection through bankruptcy and how that all works. So it sounds like you have some knowledge of all that as well. Judgments are good for 10 years. They're renewable for another 10 years. And so it could follow them probably as often as not. The way judgments get paid is that the creditor comes knocking, or the debtor comes knocking on the creditor's door and says, hey, I'm trying to buy a house, or I'm trying to do this or that. And they just ran a credit check and they found this judgment against me and I need to get it satisfied. What do I owe you? Okay, well, that really makes it easy. And maybe sometime in the next 20 years, this person is going to come to you and say, I need an interest accrues at the judgment rate.
oh,
So that's an easy, inexpensive way to go. By the way, a word of warning, conciliation court is not what's called a court of record. And so that does not stay on their credit. It isn't on their credit until you take that conciliation court judgment and you move it over into district court. You docket that judgment in district court. Now it's the same as though you started in district court, has the same implication, same 10-year longevity and renewal for 10 years. And so that would be the ideal, is you go to conciliation court, get the judgment, docket it over into district court. It was a lot less expensive and yet has the same consequences having gone to district court at the outset.
oh, I didn't even know about that. So is that something that they would have an attorney like yourself do, is if they win in conciliation, take it over? I don't personally know the difference between the different courts and where they're located or any of that. So I mean, that would be something I wouldn't know how to do. How would somebody do that?
Yeah, a lawyer would be the one to help you to docket that over into district court. One
Okay.
of, one of the disadvantages, I don't think it's an overriding disadvantage, but many courts, Hennepin County being one, do not allow a entity to represent themselves in court. They must have a lawyer. And so if you own this real estate as John Mazzara, okay, I own it as an individual. I'm going to sue my tenant. I can show up in court myself and I can represent myself because I'm an individual and individuals can always represent themselves, don't have to have a lawyer. But if you created 1231 DuPont LLC and that's the landlord, then the landlord, 1231 DuPont LLC, has to be the one suing this tenant. And it's a corporation or an LLC and cannot represent itself in many situations. It's sort of frankly up to the judge.
Okay.
Judge might say, yeah, we're going to allow that. But more often than not, you're going to find the judge is going to say, no, you need a lawyer to represent you as an LLC or a corporation. And so you've elevated your expenses by having incorporated or created an LLC. As I said, I don't think that's a controlling concern. I think the protection from liability is an overriding factor. The likelihood that you're going to have a tenant that you need to sue and that you actually decide to sue is probably remote.
Oh, I agree. I've been doing this 35 years and I've only had to do it one time.
Yeah,
And I've had tenants and for myself and my family, over that whole course of time. And everybody really has been really pretty good. It's just this one gal wasn't, but everybody else has been really pretty good. And I had to, go down there. She didn't show up and, all that kind of stuff, and then get the
sure.
sheriff involved. And so anyway, I would prefer to avoid all of that ever again, of course, if I could.
Yeah, I hear you. And I think most people are able to do as you have to successfully avoid that in most situations. And even those situations where disputes arise, negotiation is very often available. Maybe you take a discount or you do whatever and you end up
Yep.
getting out of it and not have to go the route of nuclear, as they would say, of going to court.
Exactly. Exactly. Well, we're getting kind of close to our end, and I really do appreciate all the time and information. It's been tremendous. I wanted to talk on two other topics and then open it up to you to talk about something maybe in our last 10 minutes. I didn't realize that you had the bankruptcy background. Can you maybe address bankruptcy in real estate real quickly? And if you know anything regarding divorce in real estate that you'd like to share, and then anything else that we haven't talked about today that you would like to share as well.
Yeah. So I do know a bit about divorce law. I used to practice in that long ago, and I'm glad I do not. And it's been probably 25 years or more since I've done any of that. But there is a concept in the law that relates a little bit to my estate planning practice, and that is marital and non-marital property. And so if I had, for example, a husband and wife that are doing some estate planning, and wife brought into this real estate or this marriage, a piece of real estate. Let's say that she inherited a downtown condo from her family. Okay, I need to be mindful of that. And I probably will talk to the clients about the fact that even though they haven't mentioned anything to me about getting divorced, if there were a divorce, how that divorce would implicate that piece of real estate is different than normal. That property is probably going to go just to the wife because it's what we call non-marital property. If that property that she inherited or received as a gift from her family had a debt to it, then to the extent that husband and wife both paid that debt during the marriage, it probably is been some of that property is now marital because that debt was paid during the marriage. Even if it was only wife's money that paid it, law would say that that's part of the team money. Once the team was created, the marriage was created, now that team money was used to pay that debt. There might be ways that wife could take other inherited money and pay that mortgage with just inherited money. But that can be troublesome in a divorce to prove how much of an asset is non-marital, because that gets segregated and put off to the side for the benefit of the spouse that owned it, and can be troublesome. I'm not sure that I have a lot. Well, I could share with you also that a little bit of what we talked about previously. If you have, oh, my battery is running low. If you have a debt owed by one spouse and not owed by the other spouse, there is likely going to be advantages to that non-debtor spouse in terms of being able to protect assets. To the advantage probably of the debtor spouse as well. There's some case law out there that really goes to the idea that if it's homestead property in particular, not only can you not get the interest of the non-debtor spouse as a creditor, you probably can't get the interest of the debtor spouse either, because that will implicate the rights of the non-debtor just by you attaching the rights of the debtor. That makes any sense. So there's some really strong laws out there that protect homestead properties in Minnesota, and very difficult for you to resist those. In terms of bankruptcy, when a person files bankruptcy, they have a choice to make of whether they want to choose the federal exemption laws or the state of Minnesota exemption laws. And the main difference between those laws are, under the federal system, you can keep about $21,000 worth of anything that's not specifically protected. So federal law says I can have my automobile, I can have my gravestone, I can have my retirement funds, I can have my furniture, and then I get $21,000 of anything else that isn't in those categories. So it might be I have some stock, or it might be I have an extra motor vehicle beyond the one I get to keep, or I have a motorcycle or something else. Okay, that's nice. That catch-all exemption. Under the federal or under the state exemption, you don't have a catch-all at all. If it doesn't fit within that category, you're going to lose it. You're going to have to buy it from your estate. On the other hand, you can protect up to $350,000 of equity in your home, just the same as you can outside of bankruptcy in Minnesota. And so if you have a lot of equity in your home, you're probably going to be relegated in Minnesota to choosing that Minnesota exemption, protect all that equity you have in your home. But in exchange for that, you're going to lose your bowling ball, and you're going to lose your lawnmower, and you're going to lose your snow blower, and all these silly little things. And when I worked for a bankruptcy trustee, I had a bowling ball in my office, and I had power drills, and I had all these things that were not exempt, and people, I'd have to bring them to people to sell them, and they had people that would buy all that stuff. So most often the debtor would buy it. Most often the debtor would say, yeah, I want my lawnmower, and here's $50 for it. But sometimes they say, no, I don't want it. And so we'd sell it. That's part of the way the system works.
Oh, funny. Okay. Well, wow, that's a lot of great stuff. Um, Anything else, Mike, that I'm going to say an individual. It sounds like, oh, hello, Mike. Are you there?